Okay, perfect. Good evening, everybody. Welcome to week 5, Matters Related to Children, Child, and Spousal Support. I will be your moderator tonight, and we have our speaker with us, Lenny Adriano, and today's session is November 5th, 2024. So our territorial acknowledgements, we would like to acknowledge that we are on the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. About AC Friends of Court. Our organization is a nonprofit. We began in 2011 with our first legal forms workshop being held at the offices of the Access Justice Center. Our legal forms workshop helped British Columbians access affordable legal help for a variety of areas of law. Currently, approximately 45% of Amishi Carey's clients are family law clients. And this is one of the first of its kind in BC, our program here tonight. The AC School for Family Law Self-Litigants would not be possible without the generous contributions of the below individuals and organizations. These people supported us in creating this program. And we would also like to acknowledge that some of our work is adapted from resources originally developed by the Justice Education Society, National Self-Represented Litigants Project, and Legal Aid BC. A reminder for everybody tonight that our family law school is not able to provide legal advice. We only provide legal information. And just on the screen here is a brief overview of the difference between the two. As an overview, legal advice is answering a question or providing information that is specific and directly linked to someone's case. This is not something that we're able to do. Legal information, however, is answering a question or providing information that is more general, not specific or directly linked to someone's legal case. All of our sessions will be recorded, and we will be working on emailing them to the registrants. A reminder, if you haven't already done so, to send in your participation agreements. And we ask that everybody mute your mics, remain muted, and turn off your video for privacy reasons. If you have questions, just put them into the chat box and we will discuss them at the end of the session, which is about half an hour. And again, keep your details of your case private as this is recorded. We don't want to have any of your private information become public. And then just to respect others when you're communicating with our staff. And if you have any questions, you can always send an email to us and we can try to answer as best as we can. So our objectives for week 5, we're going to go over best interests of the children, parenting time and responsibilities, understanding child support and Section 7 expenses. We're going to send information about Child and Youth Legal Center. We're not going to go through it tonight. Contact for children and non-guardians. The Child Support Recalculation Project, we will also send information after the session. And then you will be understanding who can claim spousal support and factors affecting the amount of spousal support that can be claimed. And then just a brief overview of the spousal support advisory guidelines. So tonight, like I said, we have our guest speaker with us, Lenny. She practices family law, civil, commercial, and estate litigation. She has been active in practice in British Columbia since 2011. And her practice focuses on assisting clients in obtaining a cost-effective way of resolving disputes. So we are very grateful to have Lenny with us tonight, and I will pass the presentation off to Lenny to keep going here. Thank you so much.
Thank you, Rachel, and good evening, everyone. So parenting, child-related issues, and spousal support, that's my topic for tonight. Do you see the slide, Rachel? Is it coming out? The slide on parenting time?
Yep, you're all good.
Okay,
I can see your screen.
I'm all good. Okay, so Basic. Everyone knows what parenting time is. It's your time with your child. That's the general definition. However, it includes the time of the child with your, and I'm going to say, side of the family, which is if you were cohabiting with somebody else or getting a person to take care of the child while you were at work, that is still considered your parenting time. Often it becomes an issue between parties that, well, you can't have parenting time because you work, etc., etc. But that's not really an argument against a person's parenting time because that parent is free to get childcare during his or her parenting time. At the end of the day, and you hear this often, it's what is the best interest of the child, and the concept is the best interest of the child is served when they have maximum time with a parent or the side of the parent. Um, Part of a big part of parenting is the decision making responsibility or parenting responsibilities with respect to the child. Um, there are two bodies of law that govern family law, and that's the Divorce Act and the Family Law Act. In both bodies of law, they're very similar in the sense that they both define what decision making is. And, you know, they're basically the practical things you want to make decisions on with respect to your child. And that would be their health, their education, their culture, the language they learn or use, their religion, the extracurricular activities they engage in. What's on your screen is called the decision-making responsibilities under the Divorce Act. Um, Now, it can be allocated in a family law situation. Usually, the parents compete on who's going to make these decisions for the child. But a judge or at mediation, the decision making responsibility can really be shared or allocated. Um, you're free to negotiate and decide again what is in the best interest of the child. It can be 100% decision making to one parent, the other one has absolutely no say, or it can be divided 50-50, in which case the parents will discuss whatever decisions they have to make with respect to those items, or certain items can be allocated to one parent and certain items can be allocated to another parent. Um, and again, under the Family Law Act, decision-making responsibility under the Family Law Act is called parenting responsibilities, but essentially they're the same things. Now, under the Family Law Act, the parental responsibilities are making the day-to-day decisions, making the decision where the child will reside, who the child will live in or associate, again, education, activities, cultural, linguistic, religious activities, giving consent, applying for a passport, giving, refusing, withdrawing consent if consent is necessary, receiving information with respect to health, defending lawsuits, and anything that's necessary for the child's development. So these are basic decisions parents do for a child, and these issues can be very controversial and they can be very high conflict. In practice, what I try to explain to my clients is not to make decisions until they've given themselves time to calm down. And that's very difficult, especially if the, the children's welfare is being compromised. But I always, as a practice, I always try to encourage clients to settle and discuss parental responsibilities. Judges don't really like making decisions about who gets the parental responsibility and not, but they have to. But see, this is your everyday life. This is the child's everyday life. It has to work for the parties. And a judge will not hearing you on an application for maybe what, an hour or an hour and a half is not enough for a judge to really comprehend the impact of these decisions in a family. So, as a practice, I advise my clients to sit down, really think about it, go beyond the anger. And if you have to go through a third party to do this, go do that. But think of what works for your family, because if the child is, especially young children, they're very young, these decision making um, responsibilities, they change, they adjust to your family life. So an order of the court may work for the next 6 months or for the next year, and then they're not applicable for the next year anymore, and then you'll have to go to court again. So difficult, but doable. Think about it. If you can avoid court with respect to parenting responsibility issues, I highly suggest you do that. Now, I want to emphasize this. You are self-represented litigants. You have the privilege of appearing in court and advocating or defending your position. Um, you are expected to act in a manner consistent with the child's best interest. And of course, if you're appearing in court, you must be very respectful to the judge and everybody else in that courtroom. And just a tip, I'm talking about duties of parties with respect to parenting responsibilities. If you find yourself appearing in court for any issue at all, know that you are being observed by the sheriff, by the clerk, and certainly by the judge when the judge walks into that room. So please be very aware of your behavior inside the courtroom, because they do talk about the litigants beyond those doors. Okay, to continue. All the time, we must protect the child and not include the child from the conflict arising from the proceedings. And we're not in the definition of a child yet, but the child can be a baby up to a person who is above 19 years of age, who cannot support himself or herself. Just because they're older doesn't mean they can participate, read the pleadings. You can discuss issues with your children. No, as much as possible, keep the conflict away from the children. Again, we need to help each other or help yourselves to resolve the matter through a family dispute resolution process. Now, in the provincial court, you are supposed to go through a family management conference, and in the Supreme Court, the first proceeding will be a judicial case conference. And again, as a matter of practice, I try to maximize and make these proceedings as effective as possible and as productive as possible for my client and for the parties. It's very difficult now to find court time. For those of you who have tried scheduling an application or getting court time, getting a trial date, it's difficult. And at the same time, family life goes on and on every day. So the soonest you can resolve something, it's really better for the child. Okay, and I'm going to say better for the child, not for the parent, because this family law conflict, any conflict, is always about what's good for the child, and the parents will just have to adjust. Okay, so if you can resolve the matter through a family dispute resolution process, like your family management conference, your JCC, mediation, or direct negotiations, or negotiations through lawyers or third parties, please do that. you will resolve your family case faster, you will resolve your issues faster, and at the end of the day, it's the least costly and least stressful way of resolving a matter. How do you do that? You must provide complete, accurate, and up-to-date information. Okay, and again, this is a source of conflict. People will think they should not reveal all their cards on the table. Like, I still get clients who say, I don't want to reveal how much money I make. She's going to get everything I have. Or, I don't want to show him all the savings I made. Those are mine. So, the thing is, to resolve anything and to make any order effective and enforceable, it must be based on current and accurate information. If at a certain point down the road, 6 months, 1 year, 5 years, it is discovered that you had concealed property or did not reveal certain other income, whatever agreement you have can be, I'm just going to use a general word, rescinded. It can be changed. One of the parties can go back to court and say, look, that person did not reveal all the information that we needed to know to reach this agreement. Therefore, we can cancel this agreement because I did not have full consent and full information about all her income, all her properties. So I'm going to give an example, again, as a practice point. If I have a client, I actually encourage the client to give out all the information. Why? I'm actually protecting my client by encouraging him or her to reveal all the information, because when we do reach an agreement, that agreement is a result of full disclosure and the parties knowing the entire pie. Okay, let's just give an example. If you disclose all your assets, then it's easier for us to determine the value of the family property. And I'll call it a pie. When you're negotiating a settlement, the best settlement is when both parties are actually unhappy. Okay? When both parties are unhappy about the draft settlement agreement or consent order or separation agreement with all the details, that is the best settlement you can have. Why? That means both parties had negotiated and given in to accommodate the other side. Settlement is not winning over the other. In fact, the many number of years that I've been practicing, even if you win a case or you win on an issue, because of the number of years you had to go through, the stress and the cost of litigation, paying the lawyer, paying filing fees, the win does not feel like a win anymore. Okay? The stress of family law is different from the stress of a civil litigation or a litigation over a breach of contract. It's not just money, it's emotion. So the sooner you can settle something, really, the more and the sooner you get your peace of mind. Okay, so that's with respect to full disclosure. And truly, if there is an order, you have to comply with that order. If it's a consent order, or whether it's an order after an application, you must comply with that order. Why? Because the other party can go back to court again and say, look, judge, person A did not comply with this order despite its clarity and despite its timelines. what's going to happen? That person filing an application will definitely win and get costs against you in the Supreme Court. Okay. And just so you know, there is truly a trend in family law that encourages negotiations and mediation over litigation. Parenting time. These parenting plans are all over the internet. They're beautiful graphs. You have the website here. I've given it. Lawyers use it. Individuals use it. Feel free to use it. It's free. But at the end of the day, and there's 50-50, there's 40-60, there's 3-4-4, all kinds of parenting plans that is a suggestion, of course, to what works for the parties. And again, in these times where a lot of people work from home, or there are days when a person works from home and works in the office, at the end of the day, you can download any sample parenting plan you want, but at the end of the day, you have to adjust it to what works for you and your family, and most importantly, what will work for the child. So it's not uncommon for parties to fight about, well, I can't pick up the child because I'm at work, etc., etc. That kind of statement focuses on the individual or on the parent. But if you flip the dynamic and think of what's good for the child, then maybe agreeing on a parenting plan will be less stressful, because you're not thinking about your availability. You're thinking about who is available for the child when the child needs a parent around. And again, I go back to the earlier slide. It doesn't have to be the parent himself or herself. It can be somebody standing in the place of the parent, like a partner or a caregiver. And again, I keep on saying this, family law is so fact specific. Do what works for your family. Okay. Child support. This is all interconnected. With respect to procedure, both the Supreme Court and the provincial court have jurisdiction. What does that mean? You can file your case either in the Supreme Court or in the provincial court if you have a child support issue. But what's the difference? Okay. I advise clients in general that if you have a claim for divorce and a claim for property, file it in the Supreme Court. If you don't have a claim for divorce, meaning you were cohabiting, you did not get married, and you don't have property division issues, you can file your case in the provincial court. I guess that's the easiest way, the simplest way I can explain it. Now, what happens sometimes when a person files first in the provincial court because they need their child support and their spousal support ASAP? That ASAP sometimes doesn't really happen because, as I've told you, getting court time for an application, it's not that fast. I can't say that the provincial court is faster than the Supreme Court, but what I can say is both courts have a way of encouraging you to settle first before you file all those applications in court, applications and affidavits. So if at the end of the day, if you file in the provincial court first for child support and spousal support and say, oh, I'll file divorce later and I'll file property division later, that later cannot be done in the provincial court. You will have to file another case in the Supreme Court that covers property division and divorce. So now you have two cases. You have a case in the provincial court for child support and spousal support, and you have a case in the Supreme Court for divorce and property division. Gets complicated because you cannot just switch to one court unless both of the parties agree, or unless you go through an application and get a court order to move those issues to the other court. What does that mean? Time, money, an added layer of stress. So just something to think about. But if you are in that situation already, and I apologize, I don't know the background of the audience. I'm just assuming you're going to file a case or you're in a case right now. These are the things you need to think about, because you want to lessen the stress level and the costs and the forms that you have to fill up. So you just want to simplify and figure out first where you want to file and just run with it in that court. When I say run with it, I will encourage first settle. Okay, it's expensive to do applications. Okay. With respect to child support, I'm sure I shouldn't assume. Child support is a function of the income of the parties. Okay. If both parties are employees, it's easy to find their employment income from their T1 tax returns. It's line 15000. Okay. And that's what's used to compute child support in general. It becomes more complicated when a party is self-employed, or let's say a party earns cash income, and that's very common. What do we do? What do we do? Especially when a person is hiding income because it comes in as cash income, and we know that they don't usually report the entire cash income in their tax returns. What do we do? Again, as a lawyer, in my practice, I try to convince the person who is not revealing his or her income to please reveal it voluntarily. And I will make suggestions or strong suggestions that a certain industry will have this much income according to this website. Okay. Many websites all over the place will tell you how much, let's say, a hairdresser makes, or I don't know, whatever, or a food service professional, because there are tips, etc., etc. It's a range. And if the party is revealing, let's say, 1/4 of that amount, you already know as a standard that they're not reporting everything. So I will encourage them that if you do not disclose your real income, we will have to file an application and present this evidence, because it's unbelievable that a person is only earning X amount. Okay. There are many things of doing that, and I don't even know if we have time to do it, but asking for a person's bank accounts and credit card statements will also show you the spending pattern of a person. So if the bank accounts and the credit cards, the expenses are very high compared to the reported income, then what does that tell you? There must be money coming from somewhere that you're not telling us. And those implications, those facts will be used by a party, by the other side, to convince the court to say, look, this is the imputed income that you should give this party. Okay. So child support. When you're in court, when you are in court, the judge will, depending on the evidence, can actually decide or grant an amount of support different from what is in the child support calculator. I'm saying this assuming that you are aware that lawyers, judges use divorce mate, and lay people can go to my support calculator online and calculate support. It's a free website, and you can go there and input the number of children, the birth dates, et cetera, and it will give you a more or less um, an estimate of the child support payable. In court, if you are in the Supreme Court and there is property to be divided, the court can actually give a different amount, a different award of child support. Sometimes the court, in a special provision, if it's properly drafted and if it is proven that the other party, one party, may not be able to pay child support on a monthly basis because income is very erratic, or the ability to earn income is erratic, but there is property, that it can be suggested that property division be unequal and favor the party who is parenting the child, so that child support will now be taken in a lump sum from the property share of the other party. So instead of 50-50, one party has, let's say, consistently failed to pay child support, or historically, and it has been proven, income is not constant and there's a big chance that child support will not be paid. It has been done that division of property was made unequal to give way to child support. Now, we keep on talking about a child. Who is a child? Obviously, if you were married, your child, they're under the age of majority and they can't support themselves. Under the Divorce Act, and that's what you see in your screen, they could be older than 19 years old in BC, but by reason of illness, disability, or other cause, or if they are in school and they can't work and support themselves, they are still considered a child of the marriage. Under the Family Law Act, it's easy. If you're under 19, you're a child. And again, similar to the Divorce Act, if a person is 19 years of age or older, but they can't support themselves, they are also considered to be a child. Now, child support. Sometimes, because of that support calculator and because of the difference of income, people have the notion that it's only the higher income person who pays child support. Actually, no, it's the responsibility of both parents. So if you look at the divorce mate calculation, and it's really going into the details, you input both your incomes and both parties are actually on the hook for paying child support. It's just that depending on who the child lives with and depending on who earns more money, the program calculates who pays the set off child support amount. So it's actually both parties' responsibility to pay child support. For those whose files are in the Supreme Court, and for those who had attempted a desk order divorce, the judge will not grant a desk order divorce unless they see that there is adequate arrangements for the care of the children. I've seen cases where, for example, both parties agree on the divorce. However, there are no terms, and the child support affidavit is lacking in proof that the child is really supported, your desk order divorce will be bounced. You're not going to get that divorce unless you convince the judge that there's adequate provision for the children. Now, there are some cases where the children are still in another country. Canada is multicultural. A lot of people immigrate from another part of the world. So it happens sometimes that one parent is in Canada and the other is in another jurisdiction with the child. They decide to get a divorce. But again, in that divorce proceeding, let's say it's a most of the time it's a desk order divorce because the other party is not in Canada. But there is a child, and the parent will want to eventually take the child from that other country to Canada. The judge will want to make sure that there's adequate provision. And there's no formula here. There's absolutely no formula. The judge will recognize that income in Canada compared to the needs of a child who lives in a third world country there's a big difference. It's I hate to use the word, it's less costly to support a child when they are in, let's say, a third world country. So I can't even tell you how much is good enough. You'll just have to put in your affidavit really how much you're sending to your child abroad for their support. And you need to do that because the day you will want to bring the child to Canada, of course, you'll have to report that you do have a child, and this will all just jibe. So always make sure in your child support affidavit the child has given satisfactory arrangement for support. Now, I always encourage negotiations, and some parties are very good at it. In fact, um, some parties want to settle right away and they say, okay, no, I don't need child support. Let's just do this. I don't need child support. Well, guess what? It's not the parent's right to receive child support. Of course, it's funneled through the account of the parent, but support is actually the right of a child. And parents can't waive that for the children unless there is a special provision in the division of property that gives adequate arrangements for the support of the child. Again, very important note, support is based on earning capacity and not on what the parent actually earns, but it's also the parent's reasonable capacity to earn. So sometimes it happens that a parent will work less, or I don't know, purposely decrease their income. And there's so many ways of doing this. It happens a lot, but that's the misconception. It's what I earn. No, it's what your ability to earn is. So if your ability is to earn $50,000 a year, but you're only earning 20, depending on your industry or what you do, then the other side can ask that income be imputed to you because, again, it's the obligation of the parents to work to support their kids. Okay, this is a lot of words. I don't want to say, but eventually, how do you prove one's income? And this is what's needed. I did not invent this. This is in the child support guidelines. Um, it is a requirement of law. You need to show your tax returns, your notices of assessment. If you have EI, if you're self-employed, the financial statements of your business. If you control a corporation, the financial statements of your company, etc., etc. I'm not going to go into detail. At the end of the day, you just have to show how much you're earning. Okay. Now, if I'm if I'm representing or if I'm the applicant wanting child support, what do I have to show? Well, you'll need to give the same kind of information if you're asking for Section 7 special expenses. There's undue hardship. Um, the child is age of majority, and the parenting time is split or shared. Okay, split parenting is when, let's say you have two children, one child resides with one parent and the other child lives with the other parent. That's split. Shared is when those two kids are shared at the same time between one parent on certain days and with the other parent on the other days. If a step parent is involved and parent's income is over 150,000. So what am I trying to say here? Just because you're the applicant doesn't mean you don't need to prove your income. You'll need to prove income also. And that is relevant, especially with respect to Section 7 special expenses. What are Section 7 special expenses? Well, these are expenses other than those covered by child support. For example, sports, ballet, camp, basketball, hockey, um, orthodontics, those that are not covered by extended health and medical, these are all Section 7 special expenses. College, university, tuition fee, etc., those that can't be covered by existing RESPs, or if a child works part-time and they contribute to their tuition fee, all those expenses over and above are shared by the parents, and they're shared in proportion to their income. So if the income of the parties is more or less the same, it's shared 50-50. If one party earns more than the other, they're shared according to the ratio or the proportion of their incomes. Now, difficult for me, and I apologize. I'm a lawyer, I'm not a math person. I rely heavily on divorce rate calculations. So the number of years the spouses are married impacts these numbers. The ages of the children and the number of children and where the children reside, whether they're with one parent or the other or shared or split, they all impact the calculation of child support and the ratio of Section 7 special expenses. Now, lump sum child support. This is unusual, but I think I've discussed this a bit already in passing. This is unusual, but because we want to make sure that there's something for the children to live by, if there is an asset, you can ask for lump sum child support. If it is a high conflict, very high conflict case, and there are chances that child support will not be paid, or there's a chance that one party will be leaving the jurisdiction and it will be harder for the other party to claim child support, lump sum child support can be awarded. You can ask for it and it can be awarded. Now, I just have to say something. If you're in court, and maybe some of you have experienced this already, it's really not what the truth is. It's what you can prove. And again, this is family. There's so many truths that you cannot prove in a family law file. And even if you put it in an affidavit, it becomes a he said, or she said, he. It's one person's word over the other. And again, as far as the judge is concerned, a judge will only make a decision based on what can be proven. And because, again, this is family law, and there's a lot of viva voce evidence or evidence, verbal evidence or affidavits, at the end of the day, if the evidence is on paper, anything in writing, proof of income, proof of assets, if there are independent documents that were not created by a party, that's your evidence. So just a mental note. If you're going to court, it's not what the truth is, because there are many truths and there are many layers of truths. But at the end of the day, it's what you can prove. And when you get there, very expensive to be in trial. Um, how to compute? Okay, I'm just giving the websites for the child support calculator and DivorceMate. And of course, DivorceMate is a program that you'll have to pay for, and lawyers pay for this. So what happens is, for example, I have a file and I've finished the file, but every year they have to recalculate support. The client comes to me and tells me, Lenny, can you please recalculate it? This is my income. This is my company's income. This is her income. Can you just do a calculation? And then I compute it for them. And of course, I'm very much aware that there's a recalculation program by the government now. I don't use that, obviously, because I use DivorceMate. It's a free service. You should look into it. However, I'm not discouraging you. I'm just going by what's real. You want a computation right away. If it takes them 3 to 4 months to give you an updated calculation, I don't know if you can wait that long. But if you can go to my calculator or go to your lawyer and get the computation, maybe it's worth spending X amount of dollars to do that. I'm just saying, you need to weigh the pros and the cons of anything. But to me, time is very important. The consequences of delay, the consequences of not getting an answer right away is just too heavy. So the sooner you can get issues resolved, it's always the better way. For enforcement, let us say, I'm not sure if, again, I'm not sure if some of you have won your applications already or your trials, but enforcement is when I want to collect my child support, I want to collect my spousal support. Both the recipient and the giver of the support will have to go to BCFMA, open a profile, and that's where you will see all the payments, all the arrears, etc., etc. Now, I don't deal with BCFMA all the time because I encourage my clients to pay support, full disclosure, do everything correctly. Now, because I encourage my clients to settle, I tell the other side, let's get real. Let's not do this to impoverish. If my client is the payor, you don't want to impoverish my client by asking for an unreasonable amount. So if we're going to settle this, let's settle this in a way that you're not positioning my client to fail. He or she should be able to pay what's in that order, because we don't want to get involved with BCFMA. And when BCFMA gets involved, it's usually when one party fails to pay. And so they put a lien on everything. They put a lien on your property. They make it difficult for you to renew your license, to renew your passport. If you have tax refund, they take it first, etc., etc. They make life difficult for you, so you don't even want to get there. You just want to be able to pay properly. And if you see yourself not being able to pay properly, and there's real property to be divided, maybe it's good to cut clean and give lump sum child support. Before I start on spousal support, Rachel, maybe we can do a quick break.
Yeah, for sure. We can do you want 5-10 minute break?
5 minute break would be good.
Perfect. Okay, so we'll do a 5-minute break. We will come back. Let's just call it at 6:30. Okay, we'll call
Oh,
6:30.
sure.
Sounds good. Okay, we'll be right back.
Um, okay, what is separation? Um, sorry, sometimes, sorry, I missed a slide. Who is a spouse? And in the objectives, you had wanted to know who is entitled to spousal support. Well, obviously, if you're married, if you were married, if you are married, you are a spouse. Um, Canada is a common law country. If you lived or cohabited with another person in a marriage like relationship, and you have done so for at least 2 years, you are considered a spouse. Or, and this is an or, if you have a child with the other spouse, meaning if you cohabited or lived together in a marriage like situation less than 2 years, let's say 8 months, and you have a child, you are considered a spouse with respect to spousal support only. Not property division, but spousal support only. And that's if you have a child and if you live with that person for less than 2 years. A spouse, of course, includes a former spouse. And how do you determine the length of the marriage? Again, you will see this in my support calculator and in DivorceMate. Um, Whichever is earlier of the date of cohabitation or the date of marriage, that is the beginning of your relationship. And that's important to note because it's important to note with respect to determining what is excluded property or what is family property. Also, with respect to pensions, if you're sharing a pension, it matters when you started cohabitation because, of course, it's earlier than the date of marriage, and that makes the entitlement of the other party, of course, longer. Now, spouses may be separate but continuing to live in the same residence. How do you do it? How do you say we're separated? If somebody declares, I want a divorce, I want to separate, you start living in different bedrooms in the same house. Let's face it, it's expensive to move out of your family home. So a lot of people separate, live separate lives, but still stay in the same home. It's very toxic sometimes. Sometimes it works, especially if there are children and the children still see you, even if you have separate lives. But yeah, once a person declares to the other that we're separated, then that is the date of separation. This is a very important date as well because this is where when and where you determine what is family property. Gets more complicated because you have to figure out what is family property at the point of separation. Any increase in value of that property will still be family property. Not my topic, but just an aside. Now, limitation periods. This is very important, especially for those who are cohabiting. Okay? Your claim for support must be brought no later than 2 years after, if you were married, a divorce order. You know how I said some people prioritize divorce and say, we'll deal with the property later. I just want to divorce right now. Guess what? From the time that order is granted, not the 30 days, but the effectivity of divorce, the date that the order is granted, you have 2 years to file your your claim, your notice of claim for property division. Okay, and emails are not enough. Unfortunately, no, emails are not enough. Verbal reminder is not enough. Texts are not enough. This is property we're talking about. You need to prove that this is family property. So you need to file your amended notice of family claim now with your claim for property division. And if we're talking about real estate, I will always advise do it right away because we need to file your CPL, your Certificate of Pending Litigation, and annotate it on the title to tell the whole world that this is family property and we're fighting about it and you're protecting your interest. So 2 years. Now, for unmarried spouses, It's from the date they separated, 2 years from that time. So please note, this is very important. 2 years. Entitlement to spousal support. Okay. Unlike child support, it's the right of the child, and we have what we call the federal child support guidelines. That is law. That is federal law that governs how much a child is entitled to, how much child support a child is entitled to. Spousal support is based on the SAG, Spousal Support Advisory Guidelines. It's not law, it's a guideline, but it's being used by lawyers and judges in computing spousal support. It's being used by DivorceMate, and it's being used by My Support Calculator. So again, this is math based on the parties' incomes. That's how you get the number for spousal support. But what's the difference? You need to prove your entitlement. What does that mean? It's not automatic. Just because you were married, or just because you cohabited for more than 2 years, or just because you cohabited and had a baby, baby gets child support, but your spousal support is not automatic. Okay, you need to prove entitlement. How do you prove entitlement? You tell the other party, you tell the other party's lawyer, you put it in your affidavit, you convince the court that you are entitled to spousal support. Now, these are legal terminologies. Compensatory support. What does it mean? Basically, it means you need spousal support to compensate you for the sacrifices you made early on in raising your kids. You had to give up your advancement in your career because you had to take care of the kids full time, because you had to pick them up from school, you had to be with them wherever they went, or you had to move from one country to another, or from one jurisdiction, or from one province to another, because the other spouse had to do that for his or her work. You had to sacrifice your advancement and your income earning ability. Now, 10, 15, 20 years later, you find yourself without the skills to go back to the workforce. You are going to be compensated for that. And that is your entitlement for spousal support. So the first thing I ask is, who is taking care of the child? Who was working full time? What was the situation? And again, we are in a multicultural society. It's not unique that the grandparents stay in the home of the family and take care of the kids. If that is what happened and both parties were working and no one had to give up their careers, the claim for spousal support of the person earning less may not be as strong. Okay. Another basis of entitlement would be need. And how is it defined? It's supposed to relieve the economic hardship of the spouses arising from the breakdown of the marriage. This is a definition given in a case law. But at the end of the day, again, what is practical? If one spouse truly cannot sustain himself or herself because of illness, because of some other reason that was not anticipated at all, then a court may grant spousal support. Need can be a lot of things. It's also very fact specific. The needs of a family that has a joint income of $100,000 is different from the needs of a family that has an income of 1 million. So, very wide range, very factual, also very contentious. And this is actually where we see parties hiding their income. Okay, but I tell you, if you hide your income and there was an agreement, there was the court was misled, the the party can file an application or an appeal, ask that it be reopened. Very expensive to do that, really, but it can be done. Okay. And again, entitlement to spousal support is contractual. This is when people have a marriage agreement or a cohabitation agreement. And this, it, it tells you early on at the beginning of the relationship if one of the parties will be giving up spousal support or they will just follow the law on spousal support. Now, this is my personal take on cohabitation agreements and marriage agreements. A lot of a lot of young people now are delaying marriage. They start with their careers first, or they eventually find themselves, they want to live together with their partner, with the other party, because it's cheaper. So they start cohabiting, but they've already earned X amount in their RRSPs, X amount in their TFSAs. They probably are named as a co-owner in the family home of their parents. So many factual situations that are happening now wherein there is no contractual basis for spousal support 5, 10, 15 years down the line. So I tell the young people, when you start earning money, when you start saving money, and then you find yourself in a situation wherein you are going to live together or eventually marry, think about entering into a cohabitation agreement or a marriage agreement. To me, it's just like financial housekeeping. It's the same reason why people want to, let's say, get insurance or draft a will. You're trying to shore up on your savings, et cetera, and then you will have, of course, it's not the most palatable thing to do when you're starting a relationship. But again, we're in Canada. This is the best way to protect yourself. And I'm not even going to say that. This is the best way to protect your peace of mind if your relationship does not last. And a lot of that is happening. So now, how do you get spousal support? As I've mentioned earlier, this SSAG, or the Spousal Support Advisory Guidelines, will compute, or it's the guideline. I'm not going to call it the law. It's the guideline that gives out the rules on how much spousal support or what your entitlement is or what proofs do you have to make. In DivorceMate and in the My Support Calculator, they will produce a monthly amount of spousal support. You will see in the computation child support, spousal support. On spousal support, you have a low range, you have a mid range, and you have a high range. Not sure if any one of you have seen this before, but what does it say? It's a range. It's not a set amount, unlike child support. What does that mean? It means you can negotiate if you're going to get low, mid, or high. Now, lawyers, most lawyers, sort of default in the mid amount, or people negotiating sort of default on the mid amount. And that's not really the fairest amount. The fairest amount is when the net disposable income of the family is more or less equal. And I'm not getting into this because it's too detailed. Seeing a DivorceMate calculation on screen is confusing, intimidating. It's not pretty, but only to explain that what is net disposable income? It's income disposable to the first party and to the second party. I'm not going to say husband, wife. One party and another party. Sometimes after a divorce, because of the incomes, the net disposable income of one part is high and the other one is low. Low, medium, and high will have different levels of net disposable income, and it's a graph. The net disposable income that gives you more or less equal, that's the spousal support that you should ask for. Because then it's fair. And that amount could be on the low side, on the mid side, or on the high side. Okay. And again, lump sum spousal support. Same arguments with child support. There are advantages and disadvantages to lump sum. Essentially, what it means is you're not getting your spousal support every month. By the way, spousal support to the recipient is income. It's added to your income. In your tax return, you need to add the spousal support that you're receiving. On the payor side, spousal support is an expense. Okay, just so you know, there's a tax consequence to monthly spousal support. When it comes to lump sum spousal support, it is not income to the recipient and it's not an expense to the payor because it's one amount. How do you compute lump sum spousal support? Again, in the divorce mate calculator, I don't think my support calculator gives this amount because you have no, I'm not sure. I'm sorry. I don't really use that because it doesn't have the nuances. But divorce mate will show you the lump sum spousal support on the low, mid, and a high range as well. And what does that say again? It just says you can negotiate the amount of lump sum spousal support. You can make the low your lowest or the high your highest, or you can negotiate beyond that. Again, the reason why I encourage parties to settle is because they have control of what they're going to get and they have control of what they're going to give up. If you go to court and present this at a trial for 5 days, honestly, 5 days is not enough if you have property. 10 days, 15 days, and that's going to extend, okay? If you're estimating your trial dates, add another 50%. Maybe that will work. But again, it's so hard to get trial dates. Of course, we have the new system now where you can book trials online. Where am I? I'm just saying you can negotiate lump sum spousal support. It's better because knowing the entire pie of the family property, knowing how much support you can get, knowing the range, knowing how much you're going to spend at trial, and knowing how many years you have to go through to get a judgment after trial, or maybe even after an appeal, maybe, in fact, I'm going to say for sure, money now less than what you expect to get is a lot better than money 2 years, 3 years from now with a stress, with a heartache, and with a high conflict situation. So, something to think about. What are the advantages? I think I've sort of mentioned it. If your situation is high conflict, this is a clean cut. If I'm the lawyer for the payor, he doesn't have to be bothered, he or she doesn't have to be bothered with the monthly payments. It's done. No more contact. If in the future the person earns more money, then the other person might want more money as well. Maybe it will make sense if we just do a lump sum spousal support now. It protects my client from having to reveal his or her future income. Okay. If the parties need capital to purchase or to their own properties, their own houses, it makes sense to do a lump sum to help the other party raise the capital for his or her place. So again, you can read it yourself, but these are the reasons. If I sense that there is lack of financial disclosure, and that's usually how much income the person is really making, then I will highly suggest lump sum spousal support and cut it. If I am the lawyer of the recipient, I will tell him or her, well, look, it saves you the trouble of running after the other side, continuous reminders, getting the FMEP involved. That's further contact. Just get your lump sum and move along with your lives. Okay. If there is an award for retroactive support, and again, it's a bit complicated to compute retroactive support because in my practice, I have to compute your incomes every year that there was no support. So if the past 3 years there was no support, I'm going to get the income of both parties in 2023, 2022, 2021, 2020, and onwards, and compute that, add it all up, and figure out how much arrears in child support and spousal support really is. And if we get X amount, like let's say there's $50,000 arrears in child and spousal support, how do you pay that? Well, just include it in the lump sum. Okay, what are the disadvantages of lump sum? Well, the needs and means of the parties change over time. We can't tell, but it could. It can, and usually it does. So it's a risk. Am I going to be happy with X amount of lump sum spousal support now, knowing that maybe I'm going to earn less in the future? Something to think about. Or if I'm on the other side, maybe it's better to just give lump sum spousal support now. So if my client has chances of earning much, much more money in the future, the other party will not run after it because the claim for spousal support has been satisfied. A disadvantage is if there's significant overpayment or underpayment. But then again, this is where you need to think about and you negotiate well. Knowing the facts that you know and not knowing the facts that you don't know, what is the best decision? What is the best settlement you can have? And that is why I say that the best settlement is when both parties are unhappy. Okay, it really sounds weird, but you will see the logic there. You had given in. Because believe me, both of you are going to be stressed out if you're in court. Okay. Um, if it is a lump sum award, there's no variation because it's finite, done. We're done. This is the order. We're done. We've separated property. We've given support. That's done. Difficulties inherent in calculating lump sum. Well, there's divorce mate. You plug in the values. Again, it's a function of the person's income. And if there's non-disclosure of real income, that's wherein you argue imputing income. Okay, I will tell you, I've represented different kinds of family situations from high income earners to a young person who has I'm going to say a substance abuse problem and cannot earn income well. What does the court do in that situation? The minimum they will impute is minimum wage. See, if you have kids, this is not lump sum, but this is not spousal support. If you have kids, you have an obligation to support them. And if you can't, you're going to be imputed with at the very least minimum wage. Okay. Um, that's not even an excuse. So that's sad, but that's the situation. Um, this is the last of my slides. Um, I think I've ended 4 minutes early. That's my email and that's my website. Yes, if there are any questions, I'm ready to answer them.
Okay, perfect. So questions can be entered into the chat box now. I will just pull up here, see if we have anything. Is there one more slide, Lenny? I think there might be, just that I had sent.
Okay, hold on.
There we go. Yeah, perfect.
That's it.
So
Yeah.
so just our email at the bottom here as well. If questions don't get addressed tonight, then you can certainly again just email them to us there. So I know that you kind of touched on this a little bit, but somebody's asking if the other party refuses to do a financial statement?
I'm going to ask, okay, I'm going to answer both in the provincial court and in the Supreme Court.
You can
Okay.
do provincial court because we're mainly dealing with provincial court,
Oh,
at least in this one. So yeah, just
okay.
provincial court
Okay.
would be perfect.
Well, it's necessary, and that if they refuse to do that, there's proof. You can write an affidavit and say, I've emailed him or her several times. These are the emails. These are the refusal. It's been 2 months, 3 months, 6 months, 8 months, 1 year, no financial statement. This is what he or she does. And in these website, this is how much this person usually earns. Like, let's say a carpenter, a plumber, any profession. There's usually a guideline income. I would use that, put it in the affidavit and say, he or she works X number of days in a week. I'm going to compute, I'm going to say this should be the imputed income. So you can ask politely, nicely, ask and ask again. You're actually putting it in writing because you want a recording, you want a written record. And that's what I said, right? What can you prove? You need to prove to the judge that this person is not showing his or her income. And I've asked for it 3 times, 4 times, 5 times on these dates. These are the emails. You're proving that up to now, they have not produced the requested financial statement, tax returns, and pay stubs. Then you can ask for imputation of income.
Thank you. There's a question about requirement to submit credit card statements. I think it was just back when you were talking about financial disclosure. So,
Okay, yes. No, it's not required. In my slide, I've listed out the list of things you must by law produce: your tax returns, your notices of assessment, BC assessment, proof of income, etc. Credit cards are not there. People ask for credit cards to see your pattern of spending. See, you can say that you're only earning $40,000 a year, but your credit card bills show that there's so much money and your spending is not commensurate to your income. That's one way of proving. That's why the other side wants to get it. It's not required, but if you're not honest with your income and they want you, again, if it's demanded, you're supposed to produce it. Some people don't. Some people don't ever produce it, but that's when we ask for an imputation.
um, do the courts ever not award retroactive child support?
They do. They do award retroactive child support. But you must include that in your claim for child support, right? So when you go to court, as I've explained earlier, you don't want to do it piecemeal. Ask for everything you can ask for. You're wanting child support today and the next months and the next years. And by the way, other party has not paid child support for the past year or 2 or 3. Ask for it and compute it. Now, when you're using my support calculator, you can't just use present income because present income is calculated with present tax rates. If child support, if there are arrears for several years in the past, you need to input the year that was unpaid. So you have a better idea of the arrears in child support. By the way, when I know you're self-represented litigants, it's a lot of hard work. It's difficult. It's difficult when you've studied law, and it's more difficult if this is not what you do for a living and you have to deal with the court system. Do not delay. If the other party stops paying child support for 1 month, 2 months, 3 months, file your claim right away. I'm sorry, this is the only time I'm going to be encouraging you to file your case right away because it means you're not sitting on your rights. You're not sitting on your rights for spousal support, and you're not sitting on your child's right to claim child support. Filing a case doesn't mean you're going to go litigation all the way. It just starts the process. And again, what does it prove? You have a receiving copy from court. You're showing that I asked for it right away. Because guess what? There are case law that says you will only be entitled to arrears and child support for the last 3 years. Again, I say this with a warning because it depends on the factual situation. Sometimes people don't ask for child support right away because they think, well, I can support my child anyway, right? But the point is, it's the right of the child and it's both parents' obligation to pay child support. So file your claim right away.
Okay. So I'm just going to answer one of the questions. So in terms of family assets, the provincial court doesn't deal with family assets. So we're not going to cover anything to deal with that right now. But there is, we did our session on the Supreme Court last year, and we do have some of our recordings up on the Supreme Court, on our YouTube channel, sorry. So if you have any questions about that. But you can also always email us at our info@litigantschoolbc.com. Um, so I think just to reiterate what the person was asking, and I do believe it was slightly covered, but when would a court not award retroactive? Is there like a situation that would be where they wouldn't order retroactive support be paid?
Well, without knowing any other fact, if you don't ask for it, they will not grant it, right?
Mm,
That's why I say when you file your claim or your application, put everything you can possibly ask for. And
mm,
again, what will a judge do? A judge will only make a decision based on what you can prove. If you cannot prove arrears, you're not going to get a ruling or a judgment on arrears. But if you can prove arrears, then how do you prove arrears? You didn't get anything. You've been asking for it. You were separated on X date. No money was ever transferred. Then you make that allegation, right? Because the other side will defend and say, no, I paid this, I paid that, I bought groceries. By the way, groceries, they're not child support. They don't count as child support. Okay. It
okay.
has to be cash.
Okay. Does anybody else have any questions that they'd like to submit in the chat? We do have a little bit of time left. Just give it a minute to see if there's any other questions. Um, so sorry, I'm just going to answer this question. So the comments about the retroactive support, these are a little more case specific. There is very varying determinations that a court would look at in terms of retroactive. So we're not able to say specifically about whether or not a court would look at savings per se, but yeah, so that one is not something that we're able to specifically answer in these kind of cases. But is there any other questions that people had? Oh,
Okay, I see a question here. If one side adjourns generally their claim for spousal support and judgment is reached with leave to return in 2 years, then does the 2 year statute of limitations to file claims still run 2 years after the date they were given liberty to return? Okay, 2 years is before you even file anything in court. So once you've filed something in court, within the 2 years, you're good. You're safe. So even if you adjourn that later on and you're given 2 years to rest and come back in 2 years, since that claim was filed years ago within the 2 years, it will proceed. I see the credit cards again. Well, you know, in your financial statements, there is an area there where you put debt, right? And in debt, um, credit card is a debt, right? So you are going to put there, I have $15,000 credit card, or I have $20,000 credit card in your financial statement. And then when they want to see that, you'll need to produce that. Okay, I see another question. When calculating child support payments, do the courts look at the party's savings and RSPs, etc.? Does that factor into the child payments? Again, we are in the provincial court. Okay. Now, I'm assuming you've disclosed this because even the financial statements of the in the provincial court will ask you for property, right? And I've seen this. There, some orders were made after a hearing that ordered one party to sell or to withdraw from an RSP to satisfy child support, right? It's not in the jurisdiction of the judge, but the jurisdiction of the judge is to order child support. Where that person is getting that money, the judge sees that, you have an RSP. There's actually a source, right? That can be done and it has been done. So full disclosure is good. And by the way, you know, child support is the right of the child. Let us not deprive the child of what they are entitled to. I know it's very uncomfortable to be sending the money to the other party who you dislike very much, and there's a lot of animosity, but that's the law. We just have to follow the law. And you know what? Again, as you can see, I'm an immigrant. A lot of immigrants have a hard time understanding family law in Canada because it's different from where we came from in our own countries. But what I say is, it's actually fair. You don't like what you're hearing, you don't like the judge is telling you, you don't like what you're reading, but it's actually fair because it's meant to protect the child.
Doesn't look like I have any other questions on my
No,
end.
I see this. What if? Okay. Oh, okay. Can a desk order divorce be approved even without a separation agreement?
Oh yeah,
Yes, it can.
I did address that one. It's just
Oh,
because we're not
okay.
dealing with the Supreme Court. So
Oh, okay. Okay. What if the applicant has large amounts of savings? Will the courts not want to make the other party pay because he may not have a lot of savings? Okay, this is fact specific. I think I've explained earlier that it can be used and it happened. It happened. It happens. Because again, the judge is wanting to protect the child. You can keep the rest of it. You just need to pay your child support, the arrears especially. Okay. Can lifetime spousal support? Okay, I just want to say this. I know we're in the provincial court, but a lot of the questions are mixed provincial and Supreme Court. If the savings were made during the cohabitation or during the marriage, that's family property. Okay, that's divisible as family property. Can lifetime spousal support ever be terminated, for example, waiting 10 years for? Yes, it can. It doesn't have to be lifetime. You know, I know you see like it looks like it's going to be forever, right? But again, if you look at divorce mate, there's a range and you can negotiate that range. Because again, you don't want to set yourself up or set the other party up for failure. So you might as well agree on an amount that is doable for the next X number of years. And if you're the payor and you want certainty in what you're paying, If you can afford lump sum, do lump sum. If you're okay with monthly, then do monthly and agree on a set amount. That doesn't preclude a variation application, if the situation really changes, but that's more complicated and that requires a lot more evidence. So my suggestion is if you can cut clean and cut a deal that is acceptable to you and will not make you fail in the future, then do it that way.
Doesn't look like I have any other chats. So I think we'll wrap up tonight. Thank you, Lenny, for joining us.
Thank
And
you very
thank you,
much.
everybody, for attending tonight. I will end the session now. So have a good evening, everybody.
Thank you.
Thank you.